Within film and television and entertainment more generally, one of the big things for clients is chain of title. What I mean by that is that within film and television, every film and television program is predicated on the basis that one legal person or legal persons has the right to develop, to produce, to distribute, and to exploit that film or television program. That's the Holy Grail. That's what has to be done for every film and television program. By extension, it means that every contract that's entered into in connection with that film or television program, it must reflect the fact it can't interfere with that core requirement that there is a legal person or persons that has developed, that owns that program. And it's from that legal person that other persons then are licensed rights. So for example, the most common example in Ireland would be you'd have independent production companies. They would develop, they would produce, they would exploit the television program or the film. They would then license those rights to others. In that way, you get to see your film on television. You get to see it in cinemas. You get to see it on SVOD platforms like Netflix or Amazon. So the core thing then, when you're a media and entertainment lawyer, is always having the eye in that prize. You always want to make sure that every contract you enter into respects that core legal requirement that the chain of title is protected. I mean, the best way to conceptually envisage that is that behind every film or television program, there's a chain of contracts. So there's one after another contracts, which ensure that this person or persons owns the film or television program. And if there's a chink, or if there's like a missing link in that chain, then it causes significant issues, not just for the person that owns the film or television program, but for every organization or company that has got rights in that film or television program. So to use a common example, you have a feature film produced within Ireland that's owned by an independent production company. The independent production company then licenses the theatrical rights in that film to a distributor, to a local distributor. The distributor then arranges for that film to be in the local cinema. So let's just say the writer of the screenplay of that film turns up and says, oh, you know that contract I signed, it didn't actually operate to transfer my ownership of the screenplay to you. That's not just a problem for the independent production company, it's also a problem for the cinema, because there's now a question mark over their right or ability to actually put that film in the cinemas. So it means that when we are acting as lawyers in media and entertainment, on one hand, we are focusing on the best commercial result for the clients in terms of, the usual, fees, time frame, rights, entitlements, approvals. But the real way to protect our clients' interest is making sure that that chain of title is always protected and always maintained. So when we're advising clients, we sometimes have two sometimes diverging goals. So one is, as always, like every lawyer, it's always about achieving the best commercial result for your client, the more immediate, what is the best deal that we can get here for the client. But there's also the long-term interests of the client. And I'll give you an example that comes up all the time. The best way to describe this is that not so much in television, but particularly in feature films, the visible part of feature films are the actors. And there's been more films made over the last number of years than there has been. Every decade there's an increase in the number of films. And how do you make your film stand out from the rest? One way is by having recognizable actors involved in that film. So what this means is that the representatives of the actors have quite a lot of power. They've quite a lot of negotiating power. And we find ourselves in the situation that production is about to commence on a film. The actors need to be contracted, of course. And there is a lot of demands made by those actors' representatives to get things like, approvals, entitlements, fees, and so on. And there's intense pressure on the production company to agree to those demands in order to get a signed contract, which then allows production to commence and also allows the financing to flow. Because the financing is not going to flow until you have certain key contracts like the lead actors' contracts. So we find ourselves dealing with US-based agents trying to negotiate these contracts out. The client can be saying, well, what can we do to get this signed? And this is where protecting the long-term interest of your client kicks in. And just to give you a practical example, maybe the actor says, I want to have approval over the final cut of that film. The client is going to be tempted to sign the contract and deal with those issues down the line. And that's where part of our job is to step in and to bring focus for the client. Well, what are the practical and legal consequences of signing the contract at this point, what that's going to mean after the film is produced and completed. And they're trying to sell this film to a distributor or to a sales agent whose job is to put it into people's homes. And that's one of the key things within media, and for media lawyers, is trying to balance up those, the more short-term commercial interests of getting into production and releasing financing against the long-term headache of trying to ensure that the film is efficiently and well distributed across the world. The main way that we do that is because if you work in the industry a lot and you deal with you're used to dealing with financing agreements and distribution agreements. You haven't seen the contract yet, but you know what they're going to expect. So I already know that a sales agent is never going to agree to an actor having approval over the film. They're just not going to do that, because for that sales agent to become involved and put money in, then it means that there's a potential for the film that they are putting their money into to not be the film that they're actually happy with. So I already know that's never going to fly. And then on sort of lesser points, like for example, approval over stills, in terms of transport, in terms of attending premieres, I already know that the local agent or distributor is going to have an issue with certain of those demands. So I'm already anticipating what that contract is going to say, because I suppose the best way to describe it is there's industry standard requirements globally from sales agents and distributors as to what they're willing to give to actors and what they're not willing to give. There's a fair amount of ego going on as well. They want to know that they're being the best treated on set. They want to know that they're getting the best possible deal. And there's also precedent. If they get this on your film or your client's film, it means that the next time they come to another film, they can say, well, the last time around we got this, so why do you have a problem with it? The key point here is that film and television, and media more generally, it's a bit different from other industries. There is a web of relationships. What I mean by saying that is, in some industries, they're vertically integrated. The company that makes the product is also the company that ultimately distributes that product and markets that product and does everything with that product. They get to decide everything along the chain. And within film and television, you have that also. So you have the likes of Hollywood studios that do develop projects, they produce that project, they distribute that project, they even release merchandising and consumer products. They're there all the way through, but they're not in the majority, and that's the difference. So what people might not realize about film and television is that the majority of film and TV programs are independently produced, and that means that you have a independent production company who actually develops and makes the project, but their involvement largely stops at the point that the film is delivered or the TV program is delivered. And then there may be then a sales agent, and a sales agent is a company that sells that film or TV program internationally. They sell it then to local distributors whose job is it to sell it locally within their territory, and then ultimately they sell it to the likes of cinemas, to subscription video on demand platforms like Netflix or Amazon, to television stations. So you have this intricate web of relationships. So therefore, if one party in that web is a subject of litigation, it's not just bad news for them, it's bad news for everyone in the chain. As a media lawyer, there's a there's a big responsibility for ensuring that contracts are clear and unambiguous. But also, to go back to the point I've already kind of touched upon, you have to be able to predict future requirements, anticipate what those future requirements might be. So at development stage, for example, often the only contract that exists is a writer's agreement, just commissioning the screenplay, and that's it. But that writer's agreement can't be conflicting with the rights of an Australian television station down the line. So when you're drafting these agreements in terms of tight contracts and avoiding litigation, they have to be clear and unambiguous. They have to be future-proofed. You also have to ensure that the chain of title is secured, is not being interfered with. You want to ensure that, if it's appropriate, alternative dispute resolution mechanisms are considered rather than going straight to court. And that because film and television by its very nature is internationally focused, you also have to carefully consider, for every contract, which governing law should apply and which jurisdictions courts should have jurisdiction over any disputes that arise under those contracts. One of the most important points that comes up all the time within film and television is the concept of injunctions. So, an injunction is where you have party A and party B, and they have some sort of relationship. There's a dispute between the two, and party A wants to bring party B to court. But party A is of the view that if they wait until this actually reaches court, that their interests are going to be hurt in some way by waiting that long. So they have the ability to go to court and look for an interim measure, which is an injunction, which is basically a court order telling company B to either do something or not do something. Now, if you go back to the point I made about the web of relationships, an injunction could be catastrophic for a film or TV program. Let's say company A or party A is a writer that alleges they are owed €20,000, and party B is a large-scale broadcaster. If a court, now admittedly a court is probably not going to grant an injunction in those circumstances, but if a court did, that €20,000 debt would then disrupt the whole web, and it means that the film or TV program couldn't go ahead. And the fallout from a TV program being abandoned or not being able to be distributed is huge. There's massive financial and commercial ramifications. So one of the things that we would do is every contract we try to ensure that the parties agree that whatever happens, they are not going to take an injunction. They can go to court, no problem. They can look for damages, but they will not take an injunction. And it's one of the key things that we have to ensure that in every contract, as part of that chain of title, as part of that chain of different contracts, we have to ensure that every single person who's contributing, no matter how minor, is agreeing that whatever happens, they will not go to court to seek an injunction. The thing within media and entertainment is that, virtually every, or almost every, what we would consider Irish feature films, they're almost all co-productions. That is the way the industry has gone, because to make an Irish feature film, you need to knit together financing. You need quite a lot of financing from different sources. So one of the ways of doing that is to basically co-produce with other countries. So if you take any well-known films, Irish films, they may shoot here, but more than likely post-production happens somewhere else. Different parts of production happen in different countries. So that's one example. But even for a local television program, even for those, they often have international cast members, international directors, international producers. So it means that within film and television in particular, there is always an international element. Because contracts then, you have A in one country and B in another country, whose governing law takes precedence, whose jurisdiction takes precedence. And if you're considering dispute resolution mechanisms like arbitration or mediation, again, which country do you go to? So it's one of those areas that there's no right answer. There's no, oh, well, it has to be this one. Instead, you have to look at the facts on the day. You have to look at the contract itself. You have to consider who the parties are, what's at stake, and you make a recommendation to your client. Well, I think in this case, the governing law should be, well, I think it should be Ireland and Irish because, you're an Irish company, the production's mainly happening here. But in other cases, maybe that's of no value at all because the party that you end up suing has no sort of presence in Ireland. So therefore, yes, you may get a judgment from an Irish court. That's not going to get you very far if the other party and pieces of work were actually happening in Greenland. So it's one of those areas that there's no right answer, and you need to spend time kind of thinking about what is the best way to approach this. There's also the point that nobody really wants to go to court if they can avoid it, on either side. A lot of the disputes that come up within film and television are about issues which really don't justify court time, court expenses. The most common dispute that comes up within film and television is credits. Those come up all the time, and it means that in different countries, but not in this one, interestingly, there is you can have resort to arbitration. I may be an Irish company, and I may be hiring an Irish actor or Irish director or Irish writer, and I may actually purposely choose that my contract is subject to arbitration in the US or in England. And the reason for that is because we don't have an arbitration model here to decide credits. And the last thing we want on either side, no matter who you represent, is to go to court if it's not really necessary. So what do you do instead? You say, well, here's the credit clause, and if we come to dispute, rather than going to court, we both decide that we're going to bring this to JAMS arbitration in Los Angeles, or we're going to go to under WGGB arbitration in London. And that way both parties go, well, you know what, if we come to a dispute here, at least we know we don't have to pay court fees or spend many years. You keep in mind too that the feature film production process is slow. It's not fast at all. It does take a year or two, from conception to get something into cinemas. But when you compare that against court time, it's actually quite fast. Everyone wants to see the film in cinemas, even if you're disgruntled in some way. You have a dispute, you still want to see it in cinemas. So the last thing you want is to see that film lying on the shelves waiting for something as simple as a credits clause to be worked out. The advantage of arbitration is that it happens quickly. Once you go in for arbitration, it's only going to take a few months to actually get a decision, and that will be a legally binding decision as well. Subject to appeal possibly, but it's still legally binding. And that's one of the big reasons why, even as Irish lawyers acting on Irish films with Irish companies and Irish individuals, we sometimes will have arbitration clauses in from different jurisdictions. It also happens in terms of delivery. People can have different interpretations whether a film has been delivered or not, because when people think of delivery, they think of the master tape, they think of the actual film itself. But for every master tape, there must be 50 pages of other deliverables like stills and audio description and subtitles and copies of contracts for chain of title and so on and so forth. And that can be, after credits, that's the next area that has the most amount of disputes, because delivery is often the trigger for the final payment to be made by the financier or the distributor or the sales agent. And again, you don't want to go to court over that, partly because of legal costs, but partly because of the time it would take. So therefore, again, there are certain arbitrators or arbitration systems set up in both Los Angeles and London that are ready to deal with that type of dispute. It's possible to bring it to under arbitration in Ireland. The reason why that doesn't happen is not so much that the rules don't exist, it's that the arbitrators wouldn't have the experience in delivery for feature film and television, so it's more likely to go to a different jurisdiction. The main way of doing that I've already touched upon, which is that as a media lawyer, you need to be able to anticipate what the contractual and commercial requirements are going to be all along the project, not just during development, not just during production, but right down to distribution and exploitation for the next 30, 50 years. So if you understand what the likely requirements will be by all the various parties involved in this web of relationships, then you can ensure that your contracts meet those requirements at that point that they're being drafted. That's one way of doing it. That's probably the main way that we preempt those sort of issues. From a more practical perspective, one of the things that we see happen sometimes is that people will try to operate based on like a meeting. What happens in a meeting, or what is discussed in a telephone call. So people come away with very different interpretations of what is being said verbally, and because there is a lot of pressure to move fast and get into production as quickly as possible, different parties can sometimes proceed on the basis of a discussion, and sometimes it just is not possible or practical to get a legally binding contract in place that quickly for different reasons. Often all the points have not actually been discussed in sufficient detail yet to do that. And so one of the ways that we help is to point out that, okay, forget the contract. We understand that's going to take 2 weeks, 3 weeks before we can get drafting on that. We understand that what's required for a full-on contract just isn't available yet. But do a term sheet, and a term sheet could be as simple as a 5 bullet point email. It could be a 1-page document. It may or may not be legally binding until the actual agreement is in place. Regardless, it gets rid of the type of ambiguity and the type of issues that arise from people walking out of a meeting room or of a telephone conversation having different interpretations of what's being agreed. Keeping in mind too that this is an international business, so therefore you may have people involved in the project from where we are just one small cog in the machine. You have people from LA, quite often. You have people from London, but also you may have people from any of the European countries, from Australia, from Canada. Those are the sort of countries and South Africa. Those are countries we deal with quite often. The thing is that everyone does business in their own country slightly differently, and people, it's often not intentional, but miscommunication happens, and people walk away from a discussion, particularly with massively different time zones involved, with a slightly different interpretation of what actually has been agreed. So part of the job of the lawyer is to try and preempt that and say, wait a second, let's stop now, let's try and get this in writing and make sure that everyone is on the same page before we proceed any further, and particularly before you start incurring any money or signing other contracts on the basis of what you think you have agreed. So that's one way we do it. The other approach is that because of this web of relationships, because it is internationally focused, it would all be more straightforward if everyone we dealt with was based in Ireland. But they're not. So therefore, you may be dealing with a Spanish company who may be huge in their own country, but naturally enough, we don't know who they are. Our client does not know who they are. So therefore, we spend time checking the bona fides of that company or advising our client to do that. What I mean is getting access to the local company office records on that company, looking at their financial statements, possibly sending those financial statements to accountants to check, checking about has there been any court filings, are there any regulatory issues with that company, because quite often, more often than you might expect, you're dealing with a company in a different part of the world who may be a big wig in their own part of the world, and their website may look great and they may have credits, but for us in Ireland it may be our first time dealing with them. And unfortunately it's quite easy, particularly within film and television, where there's probably quite a lot of marketing going on, to be possibly deceived by a company who is not quite what they say they are. So I think the main way to preempt these issues is anticipating future requirements, documenting in writing as soon as possible what the agreement is, even if that isn't a legally binding contract, and making sure that you understand, or making sure your client understands who they're doing business with. So Section 481 is a tax credit, and it's based upon spend in Ireland on film and TV programmes. It's incredibly important for the film and television sector in Ireland, and it's one of the ways that it helps the sector to be competitive internationally. So most countries do have a film or TV tax credit, but ours is one of the better ones out there. So, I mean, the way it works is, if a film and TV programme's budget is more than 250,000, and it fits into certain categories of production, so that would be feature film, television drama, animation, or documentary. So it doesn't apply to, for example, current affairs, entertainment programming, news, and programs that are made by broadcasters themselves, like internally within a broadcaster. It has to be independently produced. So if you fit that criteria, and a lot of projects, the majority of projects made probably do fit that criteria, it really is a no-brainer that you would apply for Section 481. So the way it works is, you work out what your eligible expenditure is. That's spend on, there's two parts to it. It's spent directly on individuals. So those individuals can be from any country in the world. And it's spent on goods, services, and facilities that are consumed within Ireland and are also provided by companies established in Ireland. So generally, within most budgets, within most production budgets, most of the spend, or a lot of the spend, will fit within that type of those criteria. So your 481, your tax credit is based, it's 32% of whatever your eligible expenditure, that's the phrase, whatever your eligible expenditure is. Now, if your eligible expenditure exceeds 80% of your total budget, then that's the ceiling. You can't get more than 32% of 80% of your total budget. That's still over 25% of your overall budget. So the way it works is, it's only available to trading independent production companies who already work within film and television. They apply to the Department of Culture for a certificate that they are eligible for the tax credit. There's certain cultural or industry development criteria that need to be satisfied, which are not particularly onerous. Once you have your certificate, at a later stage, you're able to, and subject to certain conditions being satisfied, you're able to go to the revenue commissioners and apply for the tax credit. That can be paid 100% at the very end, so you get your entire 32% at the very end. Or there is a way to claim 90% during production and then 10% at the end. And that 32% is, compared to the UK's 25%, is larger. And the fact that there's an ability to claim 90% during production and not just 100% at the end is also makes Ireland more competitive than other jurisdictions. So it's incredibly important to the film and TV industry. It's something that's used on the majority of projects that we're involved in as lawyers. And it's something that has been helping the industry to grow the way it has been over the last number of years.